Chapter 13, Indemnity to Surety, Sec. 200. Scope. In receiving application for bonds, it will often happen that the applicant, as an inducement to the surety company to execute the bond, will offer, in addition to his own indemnity, the indemnity of a third person, firm or corporation, that is to say, will offer to have such third person, firm or corporation agree, by instrument in writing under seal, to indemnify the surety against loss, that is, to pay any sum for which the surety may become liable, including costs, expenses and counsel fees. Sec. 201. The unreliability of personal indemnity. While the companies very frequently accept and indeed require personal indemnity, yet it has been found to be very unreliable, and very little faith or dependence ought to be put in it. One company reports that, in making a partial examination into the causes of its losses during the year 1912, it found that more than $37,000 was directly attributable to the acceptance of bonds on the faith of personal indemnity, which was thought to be good, but which turned out to be worthless or nearly so. The president of this company says indemnities are still costly, and we pay dearly for accepting business otherwise objectionable relying on them. The objections to personal indemnity, and the things that make it unreliable, may be summarized as follows. 1. An indemnitor generally signs the agreement on the assumption that the principal will perform the obligation, and when trouble comes, the indemnitor is slow to live up to his obligation. He generally argues that the surety company was paid for taking the risk and that the surety company ought not to look to him, who received no compensation. He overlooks the fact that the surety company was not paid for taking any risk, but merely for the use of its name and credit, and that he stood sponsor for the principal, and that it was on the faith of his guarantee that the bond was written. It therefore seldom happens that indemnitors live strictly up to their obligations, and in many cases it is necessary for the surety company to advance the money and sue the indemnitor for reimbursement. This makes the business unprofitable, and furthermore it is quite probable that in such a suit the indemnitor will escape. Such a bond of indemnity, being given without compensation by an individual in favor of a compensated surety company, will, in accordance with the old rule for the construction of contracts of suretyship, be strictly construed in favor of the indemnitor, whereas the bond of the surety company will likely be construed liberally in favor of the obligee, so that the surety company may be held liable while the indemnitor escapes. 2. The indemnitor may die and his estate be distributed to his heirs, or he may move to parts unknown before liability accrues. 3. When liability accrues, the indemnitor may be insolvent or unable to meet the obligation. This is a frequent occurrence. 4. The indemnitor is likely to learn, before the surety company, of the approach of trouble and dispose of his property and make himself execution-proof. Sec. 202. When bonds may be issued on the strength of indemnity. In view of the reliability of personal indemnity, it is manifest that very little dependence can be put in it, and the following rules are suggested for the guidance of underwriters, who are so often requested to issue bonds on personal indemnity. 1. A bad risk, that is a risk which is distinctly below the standard, should never be accepted on the strength of personal indemnity. In cases which are on the borderline, where there is some doubt about the applicant's ability to perform the obligation guaranteed, or where it is impossible or inconvenient to get full information, the risk may sometimes be accepted on personal indemnity, where the indemnitors are found, upon a verification of their financial statements, to be worth in net available assets subject to execution, an amount equal to 2 or 3 times the amount of the bond. 2. Where the deficiency of the applicant is in financial resources, as where a contractor has not the necessary funds, the risk should not be accepted on the indemnity of third persons, unless such persons are able and have agreed, by loans or endorsements, to make up the deficiency. 3. Credit guarantees, or bonds directly guaranteeing the payment of money, should not in any event be accepted on the strength of personal indemnity, although of course there is no objection to the acceptance of personal indemnity in cases where the applicant seems to be strong enough financially to warrant the execution of the bond. No matter how strong the indemnitors may be, the chances are 10 to 1 that the surety company will have to pay the money and look to the indemnitors for reimbursement, and that, as we have seen, makes the business unprofitable. and involves considerable chance of loss. 4. Personal indemnity is particularly unreliable where the bond will continue in force for a considerable period of time, and it is suggested that where the obligation covers as much as 2 years, the bond should not be accepted on personal indemnity even though the bond may be on the borderline. However, where it is deemed prudent regardless of indemnity, to accept such long-term guarantees without collateral, it is nevertheless always advisable to get as much indemnity as possible and from as many different persons as possible, for if the principal should fail, it may be that some one of the indemnitors will be alive and solvent at the end of the period. In such cases the personal indemnity should be taken only with caution and should not be made the excuse for the acceptance of a poor risk. Sec. 203. The enforceability of indemnity bonds. When the indemnity of a person, firm or corporation, other than the applicant, is offered, it is important, before executing the bond, to know that the indemnity is valid and enforceable, so that, if the indemnitors are solvent, recovery may be had. This is quite important, for there is grave doubt about the validity of much of the indemnity that is offered to surety companies. In the first place, there is the perplexing question as to the validity of such a bond of indemnity when executed by a corporation, other than a surety company. It is the rule that a corporation can do only those things which are, either expressly or by necessary implication, authorized by its charter, and it is most unusual for an ordinary business corporation to be expressly authorized by its charter to become surety or guarantor for another, and it is hardly within the scope of any business to become surety for others. Applying strict legal principles, the conclusion would be inevitable that a bond of indemnity executed by such a corporation would be unenforceable. Such a strict application of legal principles would, of course, lead to many hardships and much fraud, and the courts of nearly all the states now apply, to some extent at least, what is known as the Estoppel Doctrine. In applying this doctrine, the courts almost universally hold that where the corporation has received the benefit of a contract which has been executed by the other party, it will be estopped, while retaining the benefits, to deny its corporate power to execute the contract, and therefore, where the corporation, which offers to execute the bond of indemnity, will receive, or may be expected to receive, substantial financial benefits from the execution of the bond by the surety company, it is fair to assume that a bond of indemnity, executed by the corporation in consideration of the execution of the bond by the surety company would be held valid. It is, however, most important to recite in the bond of indemnity the facts showing the benefit to be derived by the corporation from the execution of the bond by the surety company. It is not enough to recite that the bond was executed at the request of the corporation, or that the corporation has an interest in the transaction. Facts should be stated showing just what the interest of the corporation is and how it expects to be benefited by the execution of the bond by the surety company. The courts of some of the states have gone a step further and have held that where a contract, which is ultra vires as to one of the parties, has been performed by the other party, whether the first party has received any benefit therefrom or not, the first party will be estopped to deny its power to make the contract. The contract between the surety company and the indemnitor consists of a promise on the part of the surety company to execute a bond, in consideration of a promise on the part of the indemnitor to protect it from a loss. When therefore, the surety company executes the bond, it performs its part of the contract, and where this rule is in force, the indemnitor corporation would be estopped to deny its power to execute the bond of indemnity, whether it had received any benefit from the transaction or not. While the general doctrine has been announced in nearly all the states, yet it has not often been applied in such a flagrant case as where the corporation has become an accommodation surety or guarantor for another, and it is by no means certain that this rule will universally be applied in those cases. As a rule, it is not well to rely upon bonds of indemnity executed by corporations, unless the corporation will derive, or expects to derive, a substantial financial benefit from the execution of the bond by the surety company, and unless the facts showing that such benefit will be derived are recited in full in the bond of indemnity. In the second place, a member of a co-partnership, on behalf of the firm, will sometimes offer to give a bond of indemnity. Such a bond will bind the firm only when the giving of the bond is within the scope of the partnership business, and, as we have seen, it is hardly within the scope of any business to become surety or guarantor for others. If the execution of the bond by the surety company will advance the interests of the firm, along the lines of the business in which it is engaged, and may be expected to produce some financial reward for the firm, an indemnity bond executed on behalf of the firm, by one of the members, would perhaps be enforceable. But, as a general proposition, it is wise to rely upon the indemnity only of those members of the firm who actually execute the instrument. In the third place, the indemnity of a married woman is often offered, and in about half the states, a married woman has no power to become surety or guarantor for another, and her indemnity would be unenforceable. The rule in each state on this subject is given in a note. The indemnity of all other persons, who are of age and of sound mind, would ordinarily be valid. Sec. 204. The preparation and execution of bonds of indemnity. It may not be out of place here to call attention to the importance of the proper preparation and execution of such bonds of indemnity. A slight error may render the bond void, as they are generally construed by the courts with great strictness. Each company has its own printed forms, and the essential thing is that they shall be properly filled out and executed. First, the names of all indemnitors should be inserted in the body of the bond, and at least one given name, and not merely the initials, of each indemnitor should be used. Second, the bond of the surety company, on account of which the indemnity is given, should be accurately described, that is to say, the proper date, the correct name of the principal and of the obligee should be used. It is not so important to give a detailed description of the bond, as that what is given shall be accurate. If it is not, the courts may hold that the indemnity was not given on account of the bond in question, the effect of which would be to render the indemnity void. In my own experience I have had cases where liability was denied on account of very slight errors in the description of the bond, and in such cases, the result of a suit is always doubtful. Third, the bond of indemnity should be signed by all the indemnitors, and they should sign their names just as they appear in the body of the bond, that is, with at least one given name and not merely initials. Fourth, the signatures should be witnessed. Fifth, the instrument should be acknowledged before a notary public or other proper officer. The company above referred to as having made a partial examination into the cause of its losses during the year 1912, found that more than $10,000.00 was attributable to the acceptance of faulty or deficient indemnity agreements or neglect to complete offered indemnity. It will be seen therefore that this phase of indemnity agreements cannot with safety be overlooked.